considering this panel has only 2 speakers. So good afternoon and indeed welcome to this session. My name is Henri de Waele, as said earlier, Professor of International European Law at Radbound University. There was a slight mashup maybe, but not Radbound, but Radboud, and the University of Antwerp. And I was asked to chair this panel, which I do with great pleasure, also as a member of the advisory board of CLEER. Now, indeed, perhaps also to frame this panel a little bit as far as that would still be needed. Some of you may well know our Oxford colleague Jan Zielonka, but also I think a former Commission president once described the EU a number of years ago as an empire. And obviously this was sometime before the debate was ignited on decolonizing the curriculum and the nasty ring which nowadays all things imperial do have. So this was at least then, back then, still, well, doable, even fashionable maybe. Well, I think still today there remains something to be said for Zielonka's position. In the previous panel we already saw some examples of imperial behavior or posturing, for instance, the anti-coercion instrument, quite audacious to come up with such a thing. Arms exports were raised as well. So the EU often exercises at least the force of an empire, whether you would like it or not, especially in the sphere of trade. Not unlike how, for example, the British used to pursue their preferences around the world with the aid of tariffs and blockades, not to mention gunships as well. And recent scholarship has also highlighted the extractivism of the European Union, extractivist tendencies, unduly pressuring resource-rich third countries. So that also has a certain nasty quality. Well, the panel right now, the modern equivalents, of course, here are obviously sanctions and economic restrictions, extremely topical theme already touched upon earlier. We have the 8th package of sanctions before us on Russia, agreed upon last week by the EU. So the theme of sanctions as such may definitely not go missing in this conference devoted to strategic autonomy. And we have 2 excellent speakers lined up to tackle these themes head on. First up is Dr. Machiko Kanetake of the University of Utrecht, formerly inter alia of the University of Amsterdam. She has been working a while already on dual use items and the dual use regime in the EU, on which she'll also speak today. I've had the pleasure of meeting up with you in a variety of places, from Florence to Stockholm. So it's also a great delight to be able to introduce her here in wonderful The Hague for a talk of about 15 minutes. So Machiko, over to you.
Thank you so much, Henry, for the introduction, and many thanks, Eva and Ramses, for organizing the workshop on such an important and timely topic. So I had a feeling that my presentation would be on a slightly different focus, but on the basis of previous discussions, my presentation will look at the meaning of, well, perhaps not necessarily strategic autonomy itself, but open strategic autonomy. And I would do so through the lens of a specific field of law called dual use export control. So my background is public international law, and I'm not an EU lawyer, but I've been involved in a project with EU law colleagues in Utrecht, including my colleague Ursula Jelembar, and I benefited a lot from insight from them. So open strategic economy is one of the terms that we started to be featured in various corners of the EU's initiative. Sorry, just gonna set the time. And we hear this narrative term in many different reports prepared by European Commission. So according to the Commission's summary, sort of one-page summary of this complex term, I wonder how this works. To do this or not?
Now it's the first, so the next should appear as well. You have to switch it on.
It says it's green. Okay. I think it's sorry.
keyboard instead.
Yeah, maybe I can stand there and then. 1 second. Yeah, sure. Exactly, yeah. So according to the Commission's summary, open strategic autonomy means cooperating multilaterally wherever we can, acting autonomously wherever we must. And well, apparently this definition does not say much apart from leaving the space for political flexibility. But the concept has still been invoked to guide EU's policies and political narrative on technology research and innovation, which is also related to Bram's presentation. And one of the frequently used words is to create a level playing field to facilitate and regulate trade and investment. And with the important caveat, namely such a level playing field have to be based on, among others, the respect for human fundamental rights and shared values. So as some of the discussions during the workshop perhaps touched upon, to combine aspirational openness with the EU's mandate or ambition to integrate or facilitate norms of values such as fundamental rights, give rise to multiple tensions. So, well, perhaps by definition, maybe you could. The EU's commitment to multilateralism as part of its openness may go against autonomous paths, which sounds like sort of the by definition they are, thank you so much. They give rise to some tensions. And while this tension is perhaps the whole purpose of open strategic autonomy, EU institutions, member states, and various stakeholders often give very different answers to the question of how open or how autonomous the EU's trade policies should be. And institutional tensions have also been combined with much more normative tensions among different values and norms that EU wish to facilitate. And these tensions themselves are not problematic and perhaps not surprising. The political process to resolve such tensions can lead to regulatory uncertainties, which might come at the cost of both openness and values to be protected. So these characteristics or multiple tensions, sort of almost inherent in the idea of open strategic autonomy, were evident during the legislative process of modernizing the EU's dual-use export control. So perhaps not too many people might be or have heard of the field of dual-use export control. But well, in short, the materials or technologies serve, if the materials or technologies serve both civilian and military purposes, such items are understood as sort of dual in nature. So for instance, a chemical material which can be used for our daily products, such as toothpaste, the same chemical material can also be used as part of the materials to produce chemical weapons, for instance. So if a company wishes to export such sort of sensitive dual-use chemical materials to non-EU countries, there might be export restrictions, and depending on the destinations or the types of the purposes for which those materials will be sold, they might need to ask for licenses from authorities. So such dual functions of our daily products are not limited to chemicals or biological materials, but also applicable to digital technologies. So think about facial recognition systems. They can be used to unlock our mobile phone, but the same technologies can also be used to identify military targets in conflict. So export control regulates sort of not only the physical transfer of tangible products, but also electronic transmission of data, software, technical knowledge, and ideas. So it was precisely due to such duality of digital technologies that have driven sort of intense political discussions to modernize the EU's export control regime. So the process to revise the EU's regulation on export control has started around 2013 or 2014, and it took several years until May last year when the new regulation was adopted. And one of the key sources of controversy was to decide on the EU's new approach to regulate the transfer or export of so-called cyber surveillance items, including intrusion software and facial recognition technologies. So this was actually against the EU's, well, the political background in the aftermath of the Arab Spring, like from 2010 to 2012. So there have been many media reports of the EU companies' sale of surveillance technologies to those countries which experienced popular uprising in the aftermath of the Arab Spring. So in response to these controversies, namely that EU companies are actually helping those authorities which were trying to suppress popular uprising, some of the NGOs and members of European Parliament invested their energy in reforming export controls in order to better regulate the transfer of intrusion software or location tracking device and other digital technologies, which can be used to violate human rights by those who purchase those digital technologies. So I have been following this EU sort of modernization processes since 2015, and perhaps I'm the only or one of the few researchers who have been following this. But I've been really intrigued by the different institutions and stakeholders' views on how open the EU should be and how autonomous EU should be, specifically on the transfer of digital surveillance technologies. So to begin with, sort of going back to the initial multiple levels of tensions, the EU's export control regime is based on the EU's long-standing commitment to multilateralism. And more specifically, the EU's dual-use regulation is understood as to implement what is previously agreed by multilateral or international export control regimes. So those regimes, perhaps some of you might have heard of Wassenaar arrangement. So those international regimes on export control agree by consensus sort of which materials are considered sensitive and thereby subject to export control by member states. So the idea of sort of human rights-based autonomous control over the transfer of cyber surveillance technologies was going against EU's long commitment to harmonization, to harmonize with international regimes. So in the end, after several years of debate, the EU agreed to impose autonomous control over cyber surveillance technologies, while at the same time sort of anticipating subsequent engagement with international export control regimes, which was described as sort of upward convergence. So this new regulation adopted last year strikes a delicate balance between aspiration for harmonization with international regimes on the one hand, and the EU's commitment to its values and norms. And one of the controversial points was the inclusion of human rights due diligence in the process of regulating the export of cyber and surveillance technologies. So I witnessed many points of disagreement about the relevance and the meaning of human rights due diligence in the context of export control, especially those over digital surveillance technologies. And there were also concerns about normative tensions within values and norms themselves. For instance, think about academic freedom. Export controls are, as I mentioned, applicable, not just the transfer of tangible technologies, but also the transfer of knowledge, and therefore applicable to universities' research involvement, research activities involving non-EU partners. So if export controls are rigorously used by member states to scrutinize, for instance, artificial intelligence related university projects involving, for instance, Chinese counterpart, that can create tensions with academic freedom, and that is already being one of the major concerns. And there were also tensions within fundamental freedom itself. So modernization process were primarily led by the concerns by MP members of European Parliament and NGOs over the protection of civil and political rights, such as right to privacy or freedom of expression. Those are particularly affected by intrusion software. But tighter export controls over digital technologies can also create tensions with the protection of economic and social rights in the destination countries. So just to conclude, well, legislative process surrounding dual use export control, which is a sort of a very specific field of law, but provides a fascinating example for political and normative sort of disagreement or discordance when the EU tries to be open, strategic, and autonomous in the transfer of technologies. So these multiple tensions that I have just explained, they themselves are obviously not problematic, and they are rather sort of logical consequence of this open strategic autonomy. But at the same time, at least with regards to the agreed framework on cyber surveillance controls, agreement was possible simply by narrowing down the presence of human rights in the process of controlling exports while leaving wide discretion on the part of member state authorities. So without good guidance to operationalize human rights-based export control as part of the open strategic autonomy, the EU's modernization efforts run the risk of undermining both its openness and human rights protection. So in the end, well, every decision to export technologies entail a consequence, not necessarily in the EU, but in some other parts of the world. So it is crucial, in my view, that exporters, universities, authorities, and researchers would imagine such a consequence in the process of operationalizing value and norm-based export control in order for the EU to provide a meaningful contribution to the value-based level playing field. Well, thank you for your attention.
That's a nice rallying call or call to action, Machiko. Many thanks for this very inspirational contribution, despite some minor technological hiccups. With regard to your key theme, defining dual-use items as such, among students, I noticed that drones are quite popular also as a possible example. Maybe also to share with you, amongst my students, I once had one who suggested that a handgun could qualify as a dual-use item. And I was a bit puzzled, and I asked him, well, why it would be dual-use? And he said, well, you can obviously use it to shoot someone. That's one particular use. But imagine you are trying to put up a painting on your wall and you can't find a hammer, then you can still use the gun to bang the nail into the wall. Well, I found it still a bit of an obscure example, which I had to disqualify. But anyway, that's by the side. Next up, my excellent colleague, Professor Peter van Elsuwege, who's Professor of European Union Law at the University of Ghent, where he's also Jean Monnet Chair. also co-director of the Ghent European Law Institute. And well, I call him excellent because this institute is also a Jean Monnet Center of Excellence also. So that's a perfect fit. Peter will speak about strategic autonomy and EU sanctions, in particular the challenges of coordination and judicial review. He told me that, well, to switch to Dunglish, the grass has been mowed away before his feet a little bit, but still hopefully plenty left for within a time frame of about 15 minutes. So avec grand plaisir, à vous la parole.
Thank you very much for the kind introduction. Indeed, I want to apologize. There might be some overlaps, but what has already been discussed before. But it also gives me the advantage of going a little bit faster on certain of the issues I want to discuss this afternoon. I mean, a lot can be said about sanctions, about the EU's approach to sanctions. I will focus specifically on the EU's unilateral sanctions because, and this morning, Judge van der Waerde made reference to the EU sanctions map, which is indeed a very useful tool to have an overview of all the EU sanctions in force, and you can then choose between the sanctions unilaterally adopted by the EU or the sanctions that are the result of implementation of UN Security Council resolutions. So this is the overview of all the EU's autonomously adopted unilateral sanctions. I mean, of course, a lot of them these days focus on Russia and Belarus, but it's quite a list. And if you look at the facts and the figures a little bit further, it has been found that the European Union is the second most prolific user of unilateral sanctions in the world. The first one, of course, is the US, which traditionally uses the dollar and the power it goes with it, also use sanctions as a foreign policy instrument. But we can see that the EU actually tries to increasingly do the same, also focus on the role of the euro in the global monetary system and so on. So we can see some evolution there. We have today more than 20 autonomous sanctions. Again, in total, there are more, but those might be related to UN implementations. Sanctions regimes. We have horizontal sanctions regimes on human rights violations, chemical weapons, for instance. And Ramses and his colleagues in Groningen, amongst others, found that I mean, a vast majority of all CFSP decisions actually are related to sanctions, and further research from the team in Groningen shows indeed in this graph the kind of, I would even call it exponential growth of the use of sanctions over time. And you can even see a significant increase after the entry into force of the Treaty of Lisbon, which might be related, I think, to the fact that it's made explicit also that individual sanctions can also be adopted apart from sanctions related to states. So that also all explains the significance and the importance and the increasing importance, I would say, of the adoption of unilateral sanctions. Now, very brief on legal basis, I think this is quite well known. The adoption of sanctions has this special system that it's based upon the political decision adopted within the framework of the CFSP. And then for the implementation, it depends. Some measures are implemented at the member state level, visa bans, for instance. Others, when they deal with economic and financial restrictions in the first place, they're implemented at the EU level through a regulation, a council regulation adopted under Article 215 TFEU. Now, I think this is perhaps all quite well known. One of the interesting questions is how far the EU can go with the adoption of sanctions. How can whatever, I mean, apart from the more traditional targeted sanctions on, let's say, freezing of bank accounts and so on, other new types of sanctions increasingly are on the agenda. So that might raise questions of competence. And here indeed, and it was also mentioned this morning, this RT France versus Council case is quite interesting because there the question of competence was explicitly raised. RT France basically argued that when you want to introduce a ban or restriction regarding broadcasting, that has to do with media regulation, and this is to be adopted at the national level by the French agency responsible for the regulation of media. So that was the key argument by RT France in this case, which created, which was not followed by the General Court in this case, which pointed at, I found it an interesting line of argumentation, first starting by pointing at the broad interpretation of what can be adopted in the framework of CFSP, union positions under Article 49, that can be very broadly defined, huge wide scope of measures that can be adopted there. We have a broad margin of discretion for the Council to define what restrictive measures are within the field of CFSP. And interesting, there is also a reference to Article 40 TEU in the judgment. There is not the kind of exclusive distinction between CFSP on the one hand and media regulation in this case, or links to the internal market on the other hand. It's not one or the other. They might coexist in the sense that both of them have different objectives, different scope. And I think that here not only the content and the objectives plays a role, but also the contexts in which a measure is adopted. And this is what we can see also in another case law on choice of the correct legal basis, that the context also plays a role in this kind of legal assessment. So I think this played a role here as well. This was a measure which had a clear security objective, adopted in a very specific context, being Russia's war against Ukraine. So that explains a little bit the scope of the union's competence and how this can include measures such as broadcasting bans, which I think are of different nature than the type of sanctions that the union adopted in the past. Then another broad important topic, of course, scope of judicial review. Again, also there, quite some issues have already been said, so I'll try to be brief here as well. I think that the Rosneft case here is an interesting point of reference, because there the court kind of explicitly dealt with what I would call this rule versus exception dilemma, and also in not only in the argumentation before the court, but also in academic literature. I think you can see different views which depend upon how you look at the provisions in the treaty about the jurisdiction of the court in relation to CFSP. If you look at the provisions in the CFSP chapter and you look only on those provisions, then you could argue, I mean, the rule is that the court has no jurisdiction in the CFSP, and you have the exceptions being Article 40 and then actions regarding restrictive measures. But if you look at not only those provisions of this chapter, but you look at the entire treaty, then you can come to a different conclusion. That's what the court did, actually said that, yeah, the rule is not so much that we have no jurisdiction in CFSP. No, the rule is we have general jurisdiction in the EU legal order, and the exception is that we don't have jurisdiction in the CFSP, and then you have exceptions to the exceptions, which are mentioned in that specific CFSP part of the treaties. So depending upon the perspective, do you look at the specific individual clauses, or do you take the entire treaty into account, and do you combine the reading of various articles, in particular 2, 21 and 23 are important because they create a kind of link between the CFSP part and all the other provisions of the treaties. So reading all this treaty provisions together leads us to the conclusion that, well, CFSP is an integral part of the EU legal order, and that implies that also general principles of EU law, including the principle of effective judicial protection, is to be taken into account. So this approach is important, and I would say that the court consistently applied this approach in its case law, and building upon this approach, which basically we can also find in H versus Council, as has been mentioned before. We can see also on restrictive measures that the jurisdiction of the court does not only include direct actions, but also includes questions on validity of the measures through preliminary references, as in Rosneft. Also includes action for damages pertaining to restrictive measures, as found in Bankrefa Kargaran, where again reference was made to the coherence of the system. And of course, you have the regulation where there is judicial review. So it would create a kind of very specific gap in legal protection if this would not extend to the CFSP decision itself. So the coherence of this mechanism implies that also for the CFSP decision that could qualify for this type of actions. And the last case also mentioned before, but maybe of a different nature because it concerns a direct action, but nevertheless also significant also from an autonomy part, and then maybe a more legal autonomy part of view of the union, is the fact that the reference was again to effective protection and respect for the rule of law in the EU as an autonomous legal order, which implies that arguments, counter arguments based on international law were actually not accepted, or let's say taken into account to conclude that Venezuela had legal standing and could be seen as a legal person in this case. So this all taken together brings us to the conclusion that there is quite a consistent approach when it comes to judicial review of restrictive measures. And I tend to agree that the background element or the crucial element here is that restrictive measures affect individuals. So they really touch upon effective protection of individuals, fundamental rights protection, and so on. With the remaining question, to what extent this logic has implications for other CFSP areas that go beyond restrictive measures, and when this type of argumentation perhaps is not entirely to be followed. So this is, I mean, we referred today a couple of times to this pending Kosovo-Eurlex case, but indeed I tend also to agree that this is of a different nature where we're reaching the limits of the court's jurisdiction, but this is to be followed, I would say, in the near future. Which brings me to the second part of what I wanted to discuss, and try not to speak for too long, as I said. The second part, apart from judicial review, coordination of sanctions is also important when we reflect upon sanctions as an instrument of strategic autonomy of the union. So strategic autonomy means that you can adopt your own sanctions based upon your strategic interests, that you have your own instruments, you have your own system of judicial review. But in order to make sanctions effective and efficient, then of course it's important that you not only unanimously internally adopt your sanctions, but that they can also be shared by non-EU member states. So that I would regard as also an important element of the strategic autonomy. Maybe an external element has to do with effectiveness of what the EU is doing, but I tend to regard it as an element that is important in that respect. So we might look how this coordination is organized in practice. And here I think we could make a distinction between, on the one hand, neighboring countries, and on the other hand, other key like-minded states, such as the US, for instance. When we look at neighboring countries, which I did together with also a colleague from Groningen, Victor Sepp, who is probably following online, as he told me at least. So we did a kind of analysis of the alignment of the EU's autonomous sanctions by neighboring countries. Of course, this is all based upon either voluntary acceptance by the neighboring countries or some soft law instruments. You can have some clauses on coordination, on convergence in agreements with neighboring countries, like in association agreements. We have such kind of clauses, but they're not, I mean, very very far-reaching, hard-binding legal provisions, I would say. But based upon this analysis, we can see that there is a huge difference, that for some countries it's lower than one might expect, taking into account particularly countries like Serbia and Turkey, which are still official EU candidate countries. If you want to exceed, you have to comply with the EU's sanctions anyhow. So for those countries, the rates are much lower than what could be expected. We all know with Serbia that this, creates some issues in relation to the sanctions regarding Russia, for instance. But this is one approach, let's say soft law coordination. And then we have the other important player when it comes to coordination of sanctions, which is the US, where sanctions coordination increasingly happens also through the G7 forum, and where we have, particularly with respect to the war in Ukraine, quite effective and efficient coordination, even going to a more intense stage than it used to be in the past, I would say. But nevertheless, here there might be some tensions. Reference was already made to the judicial review within the EU legal order and the problems with respect to access to information, access to evidence, and so on, which resulted in some annulment of certain designations some years ago with respect to entities and individuals that were put on sanctions lists against Iran. Fulman and Mahmoudian, I found were like such interesting cases from some years ago, and where you could see some divergence if you look at the situation in the US, because the same people were also put on their sanctions list, but there the question of sufficient evidence and so on was not entirely seen as problematic, or at least the fact that these individuals could no longer be on the EU's sanctions list did not have any implications for the US approach towards sanctions. So this might lead to some sometimes some divergence in the sanctions regimes. Another element when it comes to sanctions and sanctions coordination, and particularly when it comes to strategic autonomy of the Union, is the application of the blocking statute. As long as you have a convergence of the sanctions, there is no problem. So that's also a reason why sanctions coordination is important, I think, from a practical point of view. But once you have divergence of sanctions, then the problems might arise for EU companies, which are often in a very difficult situation, because on the one hand, they may face the negative implications of complying or non-compliance with US sanctions might provide them with problems to have access to the US market. But if they do comply with US sanctions, they might actually violate their EU law obligations under the blocking statute. And again, also this case has been referred to this morning. The Bank Milli Iran case is a very good illustration of this. And we can see that the blocking statute here is even explicitly defined as an instrument of EU strategic autonomy. The words strategic autonomy were not used in the judgment, but this is basically what the blocking statute is. It is an instrument to protect the established union legal order and the interest of the union. But as this case particularly illustrates, it's very difficult to find the right balance here, and companies on the one hand have the freedom also to conduct their own businesses. So you have the fundamental rights of economic operators as guaranteed by the charter. So they should be able to decide make their own business decisions. On the other hand, of course, they're bound by certain obligations under the regulation. So it's not entirely clear where precisely to put the right balance, which will be kind of case by case assessment. But which does not necessarily solve the uncertainty that might exist in very specific situations. And that, I think, is why it is very important that also within the EU, we're working on an amendment, a revision of the EU blocking statute, which is a key instrument together with others like the coercion instrument that was mentioned before. So bringing me to some general conclusions, I would say that on autonomous sanctions, we could see quite a consistent line of case law based upon a teleological interpretation of the treaties, providing a broad scope for judicial protection and say even full judicial protection regarding restrictive measures. That's one element. On the other element, we can have the importance of coordination, and when there is lack of coordination, that might create very concrete practical issues and challenges for companies when it comes to the application of the EU blocking statute, as was illustrated with the last case. So I want to conclude here. Hope I still have some time for questions.